Hello, folks. Thanks for joining us this beautiful Wednesday afternoon. I see people are starting to come in from the waiting room, so we're going to get things started right on time this afternoon. I want to welcome you for what is our final session of our webinar series, our Wednesday and Friday Planning and Zoning webinar series that CDRPC has put on since May. Really pleased to have a selection of diverse offerings, including today's session on planning law. So I want to thank everybody who has joined us, and I want to thank our presenters and sponsors en masse for helping us put this together. It's been a fun event series, and we're looking at putting this together in the fall in person at Hudson Valley Community College. So stay tuned for those announcements. And I want to insert maniacal laugh since we have your email addresses. We will be distributing news about the upcoming webinar, upcoming planning and zoning series. So either you can continue to receive credits for your planning and zoning boards, or you'll know where there are additional CM credits for you AICP folks. And for the rest of you, if you're looking to stay sharp when it comes to matters in planning and zoning, sustainability, resiliency, all things related to land use and development, we will have opportunities to keep your skills sharp. I do want to promote two other items that we're talking about. CDRPC offers a technical assistance program with our sister agency, Capital District Transportation Committee. So if your community is located within the 4-county capital district, that's Rensselaer, Saratoga, Schenectady, and Albany, and you have perhaps a corridor plan that requires some integration of best practices when it comes to land use or transportation principles, we're your guys. We have this technical assistance program to help municipalities. The application is very simple and straightforward. We're not talking consolidated funding level of application of pulling your hair out. This is a very straightforward application. We just ask that interested parties reach out to us first to run their project by us. Want to make sure that it fits the program eligibility guidelines and we can be of service to you. So highly recommend that program. Reach out to us if you're interested. And finally, we like to shine a spotlight on the good work that planners and non-government entities are engaged in, municipalities are engaged in to deliver public services to people across municipal boundaries. We've celebrated all sorts of things like COVID vaccine registration system, intermunicipal water connections, efforts to advise communities to the new MS4 permit regulations, 911 systems. We've made significant awards across the board to recognize folks that are engaged in delivery of public services. So I highly recommend this program, the Erastus Corning II Awards for Intermunicipal Cooperation. What a mouthful, but in essence, we're celebrating community projects and initiatives that are across municipal boundaries and in multiple partnerships. It's quite often people don't get the accolades that they deserve for engaging in this hard work, and we like to celebrate those efforts. So please check out that program. Again, very simple application process. We don't hand out awards and recognize folks if we don't get any nominations. So please submit to that program. All right, let's talk a little bit about today's session. I do want to remind folks that our attendees join with their video and audio off as per usual. We're going to hold our questions till the end of this session, but I would still encourage people to submit their questions and comments in the chat function or in the Q&A. And what we'll do is we will queue those up so we can get to those at the end of the session. So please use those two functions to put your questions in or comments in. We'll be sure to get those at the end of the session. The other thing I want to mention is that we get several questions about receiving credits. So after the session concludes, 24 hours after the conclusion of today's session, we send out automatic emails to all of our attendees. So if you joined by email, you'll automatically get if you joined registering through your email address online, you will get an automatic email. If you don't get one, please reach out to me and I will be sure to confirm your attendance and then send you a piece of paper through email that will confirm your attendance at the webinar. You can certainly take that to your municipality for consideration of credit for attending the series. We also have logged this for CM credits. So for those of you who are AICP and looking for your CM credits, we have a CM number associated with this that will get you your 1 hour. Today's session will be 1 hour of law credit for AICP credits. Okay, now that I've spit out the pre-flight announcements, we can get into our program today. The goal of today's session is to provide guidance on how to prepare administrative record to withstand an Article 78 challenge to a decision by a legislative body or a land use board. Recent notable cases will be reviewed and discussed in detail to evaluate how judges are examining administrative records of decisions on basic types of approvals, such as adoption of changes of zoning codes, compliance with SEQRA, decisions to grant or deny site plan, subdivision, or special use permits, and decisions to grant or deny requests for use and or area variances. Principles will be drawn from these cases to assist these boards in future decision making. And I like to say supplementing the record is critical, and this will be a great session in communicating to any planning and zoning board members how to make sure you have complete records for those particular cases. Joining us today is Teresa M. Backner. She is a partner in counsel at Whiteman, Osterman, and Hanna, which is right down the road here in the Capital District. So I want to thank Teresa for taking time today to join us and walk us through new case law as it relates to planning and zoning. So thank you, Teresa, for joining us.
Thank you very much for inviting me. I love doing these presentations. It always amazes me how you learn something new every day in land use and planning. And I've been doing this for 35 years, and that's still true. With Whiteman, Osterman, and Hanna, we, in our land use and planning practice, we go out every day and obtain approvals for projects, and we also represent municipalities in reviewing the projects. So we're very keenly focused on trying to make sure that when we're building a record, it's a record that will withstand a court's subsequent review. It is unfortunately true that it is easy to sue people in New York State and municipalities, and that municipalities get sued all the time. And in fact, you should not be concerned about that, because practically speaking, you can never prevent someone from suing you after you make a decision. What you do have thoroughly within your control is building a record that shows that you had findings and a written, well-reasoned elaboration for your decision. Because ultimately, the people who review the decisions made by planning boards and zoning boards of appeals are judges, and judges are looking for a demonstration that there was a written reasoned elaboration for a decision. And it's particularly important for planning boards and zoning boards of appeals, because these boards have limited statutory authority. So you have standards that you have to make decisions in compliance with. And unlike a town board, you don't have what one would call legislative authority, which as an elected official or a board made up of a bunch of elected officials, they have much more deference from the courts. So the judges are going to be focused on really two issues. Was the decision procedurally correct? Did you comply with SEQRA? Did you have a public hearing? Did you give people appropriate notice of the public hearing? Did the newspaper publish the notice correctly? All that kind of stuff. And they're also going to look at, was the decision arbitrary and capricious? One other very interesting point I just want to make is that while we're primarily focused today on state cases, constitutional law principles come up a lot in land use and planning, which makes land use and planning difficult. There are also state constitutional issues as well as state statutes that give special status to things like projects involving group homes, schools, daycare centers. So for whatever reason, in this presentation, we don't really have a lot of those special issues popping up. But I just wanted to remind you that if you're reviewing an application with respect to a church, a school, a daycare, or a group home, you need to have your attorney in the room and you need to get advice in real time as to the record that you're building, because the applicants not only have rights under the town law, but also under these other statutes. So the first case we're going to go to, and remember, we're only focusing on new cases here, so you guys don't get bored, or we don't want to keep repeating the cases over and over. So the first case we're looking at under the category of site plan review is Gershow Recycling of Riverhead versus the town of Riverhead. And this is one of those classic cases where you have an administrator of the building department in an attempt to advise the planning board, sort of exceeding his regulatory authority. So the town code authorized the administrator of the building department to provide and evaluate and advise the planning board on applications related to the town code, and to make determinations regarding compliance with the zoning code for site plan applications. So this is more under the heading of, is a site plan application complete? Is it in compliance with the zoning code? All those things that you would expect a building inspector to do. And frankly, if you're a planning board, you should have a determination from the building inspector that the proposed project complies with the zoning, and that no appeal to the Zoning Board of Appeals is necessary. That just gives you a fixed point in time where you know that as the planning board, you can proceed with the application. What happened here in this case was a denial of the site plan by the town building and planning administrator. Whoops, sorry about that. So the question raised to the court was the planning board ultimately the one with authority to decide whether or not the site plan was approved, or could the planning and building and planning administrator make a determination to deny the site plan? And the judge, looking at the code, specifically found that it was the planning board that had the authority to act on site plan applications, not the town building and zoning administrator. So since he lacked that authority, the petitioners were not required to exhaust their administrative remedies by appealing to the town zoning board of appeals. Typically, a building inspector tells you if you need a variance or if you comply with the zoning. And if you do not comply, then you have to appeal that determination within 60 days to the zoning board of appeals. And while you're doing that, particularly if it's an issue related to an area variance for lot coverage or an area variance for side yard setback, typically the planning board would say, go to the zoning board of appeals, get them to make a ruling, and then come back to us on the rest of the project. So in this case, everybody got all confused, and the town building and planning administrator took an action which he wasn't authorized to take. So the next case is the matter of Route 17K real estate versus the planning board of the town of Newburgh. This is a classic example where a party continues to sue over and over and over again regarding a particular project. Usually you find that there's an economic interest behind those kinds of lawsuits. And in this case, really the lawsuit almost rises to the level of just stupid. So what they did was Ram Hotels sought an approval of a hotel. It was a site plan approval, and it was on property that was appropriately zoned for the use. And the planning board, who was not required to even hold a public hearing, held a public hearing and held it open just for the one night. And then these people sued and said, well, that wasn't enough time to let people talk. So the holding is, the planning board has the discretion to decide if they've heard enough in the public hearing. There's no requirement to have anything more than an opportunity for the public to comment. And once that goal has been achieved, the planning board can decide to close the public hearing. Special use permit category. Okay, in this case, there was an application by Rockland Tree Expert Inc. to the planning board of the Village of Wesley Hills. And they asked for the approval of a site plan which did not have frontage on and practical access to two major roads. And the planning board, for whatever reason, believed that they had the authority to waive the zoning code requirement for frontage on and practical access to two major roads. And in fact, there was no waiver authority granted to the planning board under the zoning code. So the only way that this particular application could have been approved was if they had applied to the Zoning Board of Appeals for an area variance because they could not meet that requirement. So this gets to the point I made in the beginning, which is that the planning board really has limited authority, and it only has the authority that New York town law and the local zoning law grants to it. So it's not uncommon to find that the planning board can waive requirements related to parking, for example, or waive requirements related to lot coverage under certain specific circumstances. But if there's no waiver allowed or specifically authorized, then it has to go to the ZBA. The next case here also involves the Board of Zoning Appeals for the town of Hempstead. People like to sue Zoning Board of Appeals, I would say, more than they like to sue planning boards. I'm not really sure why, but it is definitely true. So in this case, it's a little bit of a different procedural thing. The petitioner was denied an application for a building permit by the building inspector because the proposed Zinburger restaurant violated the governing floor area ratio requirements. So that's not unusual that could happen, especially if you have something like a lot that's a prior non-conforming lot. So what the petitioner did here is they applied for a special exception permit to exceed the floor area ratio, and the town zoning board of appeals just apparently said no. They did not give them any reason for their decision, and it is clear from the holding of the court that the court believes that the reason why it was summarily denied was because of that terrible basis for a decision, generalized community objection. So if you as a board don't supply a series of findings and determination, then the court is likely, particularly in a contentious proceeding, to say, hey, that's not enough. You may have made your decision based on something that's inappropriate, or based on nothing. And so there's nothing for us to uphold. So the court said the ZBA's denial showed little to no evidence that the granting of the exception permit would have had an undesirable effect on the character of the neighborhood or would adversely impact the town. So in the absence of a determination, the court will not supply one for you. You have to tell them. And that can be a fancy resolution drafted by the board's lawyer, or it can be a determination in the minutes of the meeting, but it has to exist. It can't be assumed. The next case, again, regarding a zoning board of appeals, and you can see immediately that this case is going to get extra special scrutiny because it involves a children's home that's been in that location, you know, since the early 1900s. So the town received an application from the Sunshine Children's Home to amend their special use permit to expand the facility and to provide more space so that they could house more children with special needs. And the town granted the amended special use permit and issued a negative declaration under SEQRA. And the neighbors of the facility brought an Article 78 proceeding against the town, seeking to establish that the frontage or access requirement required a use variance. And the court totally dismissed this, finding that the ZBA properly granted the Sunshine Children's Home an area variance and properly approved the application for an amended special use permit. It is confusing to people that a frontage or access requirement, like you must have property that's located on a state highway in order to have a nursing home. If there's a statement like that in the zoning code, that is not a use restriction, that is an area restriction. So anything that's dimensional, anything that says that you have to be somewhere or close to something is an area variance. And in this case, really the court found very compelling the fact that the home had been there for a long time and, you know, upheld without a lot of discussion the town's determination. So the next category of cases I've grouped under SEQRA, just because SEQRA is a part of the determination that's being made here. So this is Coalition for Cobbs Hill versus the City of Rochester. This is apartment units for affordable senior housing. So you'll see, in line with what I said at the beginning, that you shouldn't feel compelled to take a different course of action simply because somebody's going to sue you, because people sue over children's homes and people sue over senior housing, which just frankly blows my mind, even as a lawyer, how people sue on these things that are basically things that are needed and generally speaking at locations where they're allowed. So in this case, it was a relatively complicated procedure for the project because it involved affordable senior housing. So there was a zoning manager that had that could act as an involved agency. The City of Rochester Planning Commission could have been an involved agency, and the mayor could have been an involved agency. And that all derives from the special local requirements with respect to affordable housing, in this case, senior housing. So, so first it went to the zoning manager, and there was a memorandum of agreement that the zoning manager under these circumstances would act as the lead agency. So he designated the project as a type 1 action, submitted the project to the county planning department, and went through all the procedures of SEQRA and ultimately issued a negative declaration. The City of Rochester Planning Commission had its own independent authority over the project and conditionally approved the project. And because there were some changes made during the course of the project review, the zoning manager also issued an amended negative declaration. And please ignore the based on SEQRA violations. It was based on the amended site plan. So what happened? Tenants and residents of the adjacent neighborhoods filed an Article 78 proceeding. They argued that the lead agency's negative declaration was adopted in violation of SEQRA procedures. They argued that the conditional approval didn't meet the special permit approval standard. And they argued that because there was a change in the project design, that it should have been re-referred back to the county planning department. So one of the things I like about this case is it really goes through sort of the standard arguments that are made in these cases procedurally. And so the court, having a full record in front of it, went through each of the allegations, first finding that the zoning manager's negative declaration was appropriate and took a hard look at environmental conditions by looking at potential impacts of the project on traffic and also on mitigation measures. The lead contamination issue was a bit of a red herring because it hadn't been raised properly before the boards, and it had to do with a shooting range that operated like 100 years ago. So the court didn't really give any credence to arguments regarding that and found that, it wasn't raised below, therefore it's not appropriately raised to the court either. They also made the argument, which people have been making forever, that if you change the project during the course of the project review in order to eliminate impacts, that a subsequently issued negative declaration is a conditioned negative declaration. The courts have totally dismissed those arguments. In fact, they've appropriately found in many cases that where you incorporate mitigation measures into the project design as part of the review, that does not result in an inappropriate condition negative declaration for a type 1 action. The court also said that the CPC appropriately looked at all of the standards and findings and made written findings. And lastly, and most importantly, even though the number of the apartment units to be constructed and the height of the buildings increased since the original referral, the court did not find that it was necessary to resubmit it to the county planning department. Now, I will say there is no reason that this type of an argument should ever be made, because if you have any doubt as a planning board that their changes to the project are not minor, it's much easier just to re-refer it to the county planning or have the county planning director send you a note saying he looked at it and the changes are minor. So best to forestall that argument rather than taking any risks, in my opinion. The next case, also a very interesting one that raises a lot of issues, is the matter of Peachin versus the city of Oneonta. So the city of Oneonta had a municipal parking lot that it decided to engage in land use renovation, to try to make it more than just a parking lot, but to use it as an opportunity to have more apartments, some mixed use building, and also in conjunction with the local college, which is Hartwick College, to run a testing lab on the site as well for grains. I don't know if this had to do with breweries or what, but they certainly wanted to get more use out of it than just a municipal parking lot. The City Planning Commission served as lead agency, designated the project as a type 1 action. and then issued a negative declaration, approved the project, waived a zoning code requirement that 90 off-street parking spaces be added to accommodate the use. So in this case, the Planning Commission, as is typical, had a specific authorization under the City of Oneonta zoning code to waive the requirement for parking spaces. And this is very common within cities because often there are, and in this case, there was a study that was done showing that there was sufficient parking elsewhere to accommodate this use. So the concept of shared parking and parking usage and studies is something that comes up frequently in this context. The petitioners were a group of adjacent business owners who really must have done a bad job at making allegations about what their interests were, because this issue gets to the heart of the concept of standing and whether a petitioner has standing to bring an action. And you really look at three specific criteria. Were they injured in fact? Did they allege an injury? Were they injured differently from the public at large? And is it an injury that deserves to be looked at under the code that they're seeking the relief? Now, in this case, the court resoundingly said, no, they lack standing to challenge the negative declaration. Their concern is economic and competition and the availability of parking spaces for their customers. So the court said that doesn't meet the prong for bringing a challenge under SEQRA. They raised concerns regarding traffic, but none of those concerns or injury, if you will, related to them specifically. It just related to the community as a whole. And then lastly, in terms of injury in fact, even assuming they could raise the other issues, they presented no proof that they would actually be injured. They also had a throwaway allegation that, you know, when all this was built from their businesses, their view of the rolling hills around the city of Oneonta would be obscured. And the court found that was too little too late and didn't really give them standing to challenge the negative declaration. This is a really interesting case to review in terms of evaluating who's objecting to what and whether they're actually raising a cause of action or an injury that they have the ability to do so. Courts, a lot of times courts will, even though the petitioners lack standing, they'll also look at the other issues and say, well, even if it's true that they had standing, the Planning Commission took a hard look at the parking impacts. And it was clear that the Planning Commission had done that. They had had a number of public hearings. They had thoroughly looked at an older study that talked about parking usage. You know, they had a very well-written decision under SEQRA and also under the standards that applied under the zoning code. This case, matter of Neiman versus the town of Warwick, is very interesting because it's a situation with municipalities are faced with all the time, which is you have a use in town that's been in town for a long time. And while nobody was looking, they expanded the use. And generally, this comes up when the user, the owner, is in the process of selling the facility and somebody looks at their approvals and goes, how did you go from 74 campsites to 154 campsites? And then they have to come back to the town to try to ameliorate what is a situation that has already occurred. So they the town of Warwick must have undertaken some sort of enforcement proceeding against the BBFC, and then they sought to settle the proceedings with an agreement with BBFC, which required BBFC to obtain an area variance and other relief from the zoning laws. The planning board as lead agency adopted a negative declaration, and they held public hearings. They engaged in all the procedures required by SEQRA, and they ultimately approved BBFC's application for site plan approval and a special use permit. The people who were unhappy about this sued, and they alleged that the negative declaration in particular did not evaluate the environmental impact from the increase of 74 campsites to 154 campsites. And apparently the negative declaration based its finding that the campground had been operating illegally for many years without any impact on the environment. Now, the problem with that, as far as the court was concerned, was that the planning board didn't look at or evaluate the potential environmental impacts. They must have just summarily said, well, they've been doing it for so long and nobody's complained, you know, what's the problem? So you can't do that. Even if you're trying to ameliorate a situation where someone has vastly expanded a facility without seeking the appropriate approvals, you kind of have to go back to ground zero and evaluate the environmental impacts of going from 74 to 154. Noise, traffic, you name it, you can't just engage in sort of a pro forma analysis. And remember, you know, in this case, the Supreme Court had upheld the determination and the appellate court disagreed. And that's kind of unusual. So there must have been a substantial defect in the record. The other problem here was that the appellate court also took issue with the development agreement and the way in which the town board, the town of Warwick, had structured the agreement and felt that it was an illegal agreement because of the way in which it talked about rezoning the site. So this is matter of Hart versus the town of Guilderland. These are locally famous cases, which I like to put under the heading of, why don't we have a Costco already in Albany? I personally would like to shop there. So I hope that soon people stop suing over this particular project. This is next to the Crossgate Mall. There's property there that's owned by Rap Road Development LLC, which complies with the zoning in the town of Guilderland, and which was subject to a positive declaration, an environmental impact statement, and a SEQRA statement of findings. So this was a type 1 action that looked at a bunch of disparate projects. It looked at the residential development at 222 apartment unit residential development, the Costco, and the refueling stations. That should be grocery warehouse, not just warehouse. And the planning board very thoroughly undertook a cumulative review of the project, looked at all impacts. The Supreme Court decision found that the EIS was insufficient and took issue with all of the decisions of the planning board. But on appeal to the third department, the appellate court took the how do I say this? They took the standard approach to such cases and said, look, if they took a hard look, they followed all the procedures correctly, and they made a written reasoned elaboration the basis of the determination, we are not going to second guess that as judges. So they looked at all the impacts that had been evaluated, impacts to birds and bats, visual impacts on a historic district, impacts on community character, compatibility with the goals of the transit district, which was specifically established for this property previously, all the proposed mitigation measures, and they looked at several alternatives to the proposed development, alternative uses, alternative arrangements, and the project changed substantially throughout this review. Hang on a second. So at the end of this, the Appellate Division 3rd Department upheld all the determinations that were made by the Planning Board. Not satisfied with that case, they continued to sue, and this should be decided May 5th, not March 5th, and it has been published since, so you can find it on the web. Another series of petitioners continued to challenge whether or not the Planning Board took a hard look at the cumulative impact of the Costco development. And these petitioners had argued on a slightly different basis than the previous ones. So the appellate court really treated these as companion cases. And they again looked exhaustively at what the Planning Board had done and whether they had taken a hard look. And the appellate court found that the Planning Board's determinations were rational, and that they appropriately complied with SEQRA. So hopefully we'll soon be able to shop at a Costco, but I don't know. So the matter of Van Dyke versus the Town of Greenfield Planning Board, this involves Stewart's building a new manufacturing and distribution center. The Planning Board issued a negative SEQRA declaration and site plan approval. It was a relatively simple process. And there were really two main issues that were raised by the petitioners: that they didn't agree with the stormwater conclusions, and that they felt they should have gotten a letter from the Army Corps of Engineers telling them they didn't need an Army Corps of Engineers permit, which I will tell you is a hard thing to get these days. So the determination was challenged, and the appellate court held that the Planning Board took a hard look at the stormwater impacts and made a reasoned determination that the capacity of the existing system was adequate to handle the increase in stormwater runoff. And they also found that the Planning Board's reliance on a private delineation not confirmed by the Army Corps of Engineers was reasonable, because it showed that the project was designed to completely avoid Army Corps regulated wetlands. And they also did have a determination from DEC that state wetlands were not going to be impacted. Of particular note here is stormwater is a very expert derivative type of an evaluation. So in this case, the Planning Board looked at a SWIP that was developed by a licensed engineering firm, and then the Planning Board had a licensed engineering firm review the SWIP on behalf of the Planning Board. So what the people came up with were allegations that similar to, well, you know, we don't believe this. We believe that the stormwater runoff is still going to be bad. The soils underlying it are bad. It's the classic situation, very similar to traffic, where it is difficult for participants in the process who are not familiar with stormwater to really make an argument that's going to hold up, absent retaining an expert consultant themselves and having them look at the system. And then I think the ruling with respect to the Army Corps was basically, was it reasonable for the planning board to rely on a qualified private delineator's opinion as to where the wetlands were, and the fact that the project would not have an impact on the federally regulated wetlands? And this is not the first case to make that determination. There have been other cases that have similarly said that the planning board's reliance was reasonable. This case we mentioned previously. I put it in here under SEQRA as well, because one of the arguments that they made in that case was that the planning board couldn't have taken a hard look at the environmental impacts of this hotel because they didn't look at the signage package at the beginning, but allowed them to come back with the signage package. And the court, as you would expect, determined that no, the planning board took a hard look at environmental concerns, including visual impacts, and that they did not treat the signage as an independent, unrelated activity. And this is important because it's often the case that signage, the exact signage proposal, comes later in the process. But as long as you looked at visual impacts, and in particular, as long as the signage proposal complies with the underlying zoning, you know, this is not enough to overturn a decision. This case involves the town of North Castle and an amendment to the town's zoning ordinance to allow structured parking as a special permit use near, in this case, near to the airport. Now, there already was structured parking and some sort of parking facilities being offered at the airport by the petitioner in this case, which would be Airport Parking Associates, LLC. And they argued that the town, in amending the zoning code, had not evaluated the environmental impacts of this zoning change. And the court clearly stated, look, the only injury you've alleged is an increased threat of business competition, and that does not get you standing to challenge, to get your day in court. So variance is here at the end. This is an interesting one. So somebody showed up in front of a zoning board of appeals and asked to subdivide property into 2 lots. Each lot under the law was supposed to have 20,000, I'm gonna assume, square feet. And what they wanted to do was divide a parcel such that they were seeking seeking area variances to allow much, much smaller parcels to be used. And their purpose and the benefit sought was to build houses on the lots. And the court, looking at the area variance that was requested, found that the area variance was very substantial, and it was over 50% in both cases, and they upheld the denial of the ZBA. So they will do that even for area variances, which are much easier to get than a use variance, but you still have to, as the applicant, try to meet the standards, and they obviously did not in this case. Greenville Fire District versus the Zoning Board of Appeals. In this one, there was a contract vendee with the Greenville Fire District the district was selling them property that they wanted to build an assisted living facility on. And they needed an area variance because the zoning code would allow that kind of a project only on a parcel that was more than 4 acres in size, and which was, and in addition to being on a parcel that was too small, it was more than 200 feet from a state or county right away. And the Zoning Board of Appeals acted as lead agency, issued a negative declaration, and approved the area variance. The petitioner brought an Article 78 proceeding alleging that it was a use variance, not an area variance. And so this is another situation, however, where the petitioner failed to meet state laws with respect to statutes of limitations. So the Zoning Board of Appeals issued the SEQRA negative declaration and granted the area variance. And when they granted the area variance, from that point forward, the challenge to both the negative declaration and the area variance had to be made within 30 days of filing the ZBA decision in the town clerk's office. And the court found that the statute of limitation began to run on June 27th, 2017, and the petitioner didn't commence the proceeding until August 11th, several days after the 30-day period. So that's it. You lost your day in court, you're done. Statute of limitations are put there to cut off litigation. And in this case, the court said, you didn't make it. So comments or questions? I have like 6 minutes here. So I'm happy to answer any questions that anybody has.
Yeah, we didn't get anybody reserving their spot as far as putting them into the Q&A and chat yet. So I would ask folks, if you do have questions about these cases, can you please use the Q&A or chat function to pass them along. In the meantime, I guess I'll ask a question, Teresa, and maybe I'm putting you on the spot here. In regards to the Costco case, the state Supreme Court had one view of the effort that the planning board put into a hard look over the case, and then the third department disagreed. What was the nature of the disagreement overriding the state Supreme Court's decision? Do you happen to know? Or?
It was a really interesting case because the planning board had really followed the SEQRA procedures, and they had required an environmental impact statement. They had had a number of public hearings, and then an FEIS had been prepared addressing all of the comments. And then the planning board had issued a SEQRA statement of findings, which was very thorough and which had looked at all of the issues that the lower court found that the petitioners had made a compelling argument. When you look at the Supreme Court decision, the lower court's decision, they specifically disagreed with the factual conclusions that were made by the planning board. So it didn't exhibit any deference to the planning board's decision-making process. So if you think about it, I mean, from a bulletproof process, if you have an environmental impact statement and you have a finding statement, and if you've complied with all the procedures, then you would expect that if the board concluded that an alternative wasn't practical, that it was based on a good factual record. So when you have negative declarations that are going up on appeal, they can often be a little more sketchy, you know? So you can definitely see where a court would go, you didn't explain that good enough, go back.
Yeah.
In this case, the lower court seemed to be compelling conclusions, not compelling evaluation. You know what I'm saying? So that it was kind of a shocking case from that standpoint.
Yeah, I thought it was interesting because I read the decision by Justice Lynch, I think it was.
Yes.
And he had some very plain language explanations of why he sided with the petitioners. There were a couple points where he wrote, "Are you kidding?" in the decision, which I thought was rather unusual. But it was an interesting case.
It is an interesting case, yeah.
So we had a question. Anonymous attendee asks, I don't know why it comes up that way. Should a planning board or zoning board of appeals always issue a negative or positive decision? They said they've seen some just acknowledge SEQRA and declare lead agency and then take no further action.
Yeah, once you start this SEQRA process in the review of an application, a planning board and a zoning board of appeals must follow the SEQRA process. The only situation I am aware of where you can sort of opt out of the SEQRA process is if it's an exempt action. And that may be what's happening in that case. The ZBA may be declaring itself lead agency and then determining that it's a type 2 action. That's probably what's happening. The only place where you can legitimately have SEQRA started but not continue it is as part of a zoning application. So if a town board gets an application to rezone 200 acres in the town and they don't want to entertain it, they're not going to approve it, they don't have to do SEQRA. They can just say, nah, we're not going to do this. So I bet you what's happening there is they're determining, the ZBA and the planning board's determining it's a type 2 action. And one thing it's good to know is that DEC did expand in their last amendments to the SEQRA regulations, the list of what is a type 2 action. So I always go back and look, because type 2 is a good type if you can make an argument.
Yeah, they seem to be a lot of ministerial decisions in relation to like signs and fences.
Well, signs and fences, or if you're expanding something less than 4,000 square feet, or if it's an accessory to an existing use, which is good because, you know, who wants to do an EAF on a shed? Nobody.
Right. Yeah. So we don't have any more questions or comments. I really appreciate your time, Teresa. You have your contact information. So if people want to reach out to you, they can do that. Really thorough examination. I like that you had a local case in there for those of us from the Capital Region to lean into. So thanks for including that as well. I don't have any future webinars to tease. This is the conclusion of our webinar series. So I want to thank folks for joining us. We will be sending out our confirmation emails 1 hour after the webinar series. And for those of you that requested an invoice or pay later by check, we'll send out those invoices to registrants so they can pass them on to their municipalities for processing. So that order of business will be handled. Stay tuned. We'll be announcing sessions in the fall. It'll be a live session at Hudson Valley Community College. The webinars, as far how long will the webinars be available? They have been permanently archived. So they'll be available on the Eventbrite site for a couple of weeks for people that paid to view the webinar series. We'll eventually start transitioning those to listed and on our YouTube channel. Right now they're unlisted, so only people that paid for the webinar series have access to those. I don't have a time frame on when those will go public, but for those of you who are joining us for the webinar series, they're obviously, you're able to dial in on them straight away from that Eventbrite page. We'll also put the archived materials of presentations on the CDRPC website for the archive of things that were like handouts or PDFs of presentations that weren't the video. So those will be available on the CDRPC website as well. Just follow links to the Planning and Zoning webinar series through the CDRPC website. So with that, I want to wish everybody a happy Wednesday afternoon. And for those of us who are Planning and Zoning Board members, I feel like we're much sharper now. I have a meeting tonight and I'm going to be thinking about this session while we're in our meeting tonight. So Thank you, everybody. Thank you again, Teresa, for stepping in and hosting this session. I very much appreciate it. And take care, everybody. You'll hear from us as far as our fall offerings in short order. So take care, everyone. Bye-bye.